The panel to begin this hour, NBC's Garrett Haake, MSNBC's Katie Phang, former U.S. Attorney Chuck Rosenberg, MSNBC legal analyst Lisa Rubin, and former FBI General Counsel Chuck Rosenberg. Boy, power panel, right? But Garrett, I'm going to start with you if I can. Look, when I read this social media post by Donald Trump, he promised a large, complex, and detailed report by Monday to refute this indictment. Is it bound with footnotes and ready to go? I wonder, is his team now scrambling to come up with the report? What do we know about it?
Chris, very little. I mean, look, Tolkien wrote large, complex, and detailed volumes, too, and they were fiction. And I can't imagine that anything in this report would be anything other than that. The facts that Donald Trump says he wants here just don't exist. There weren't dead people in Georgia or Florida, for that matter, voting in the numbers that he would need to make this work. There weren't young people. There weren't out-of-state people. There weren't ballots stuffed in machines. I mean, if you go back and listen to the hour-long phone call that Donald Trump and Mark Meadows made to the Secretary of State here in Georgia, which has been kind of reduced on air so many times to that snippet about finding the 11,000 plus votes he needed to win in this state. There is every conspiracy under the sun presented at that time, more than 2 years ago now, looking for something that would provide exactly what Donald Trump describes in that Truth Social post, evidence that would exonerate him. At no point in the intervening years has that evidence been produced, and I don't anticipate it will be produced on Monday. What he's going to present in Bedminster on Monday is a huge question mark right now, but it will not be what he says it is. That simply doesn't exist.
Garrett Haake. Garrett, thank you very much. Andrew Royceman, let's talk about the scope of this indictment. I mean, 19 people in total, multiple different counts. It goes through emails and text messages and phone calls, tweets, things that taken individually don't look like criminal problems. But taken as a whole, the prosecution argues, is a criminal organization furthering a criminal effort to overturn the election. Because it's so big, is that risky for DA Fani Willis?
The answer, I'm going to be a lawyer, yes and no. So the yes is you want to present a clear, clean story that's not too complicated. This reminds me in Enron, where that was complicated, and it's like, how do you present that to a jury? That's the risk. But as Fani Willis herself said about bringing a RICO charge, is that she wants to present the whole picture to the jury of what happened. And that I do think is the right approach, which is speak up to a jury. You don't have to dumb things down. You should, rely on their common sense. So here, this does encapsulate, in brief, frankly, everything that we know that happened.
Do they run a risk, though, of a jury or a juror saying, isn't it his right to try and investigate stuff? Isn't it his right to say whatever he wants? Why is this criminal?
Yeah, so absolutely, it is his right to say whatever he wants publicly. As a matter of fact, the press conference that he's about to have, it might be fiction, as Garrett said. That's totally fine. That's what he's entitled to do. It's acting on it or speaking in a way that furthers a crime that is a problem. So, for instance, the charges that are making a false statement or perjury, those are pure word crimes. Those are just, and everybody under the sun knows that that's a crime. And they're prosecuted every day of the week. So it doesn't even require action. I also think the going big here, the big difference between this and what Jack Smith did is Jack Smith had unindicted co-conspirators. These are indicted co-conspirators. This is holding people to account for what they did. If you think about what the January 6th trials have been, that is holding people to account who were the foot soldiers. This is so important to the rule of law because you don't want to just look at the very top, which is Donald Trump, but what about all the enablers? It is really important that they are being held to account.
Andrew, one of the reasons that we've all been discussing and learning from you and Chuck Rosenberg and Lisa and other lawyers is Jack Smith has a time, the clock is running.
Absolutely.
Because after the election, if he is the nominee, if he's elected, he can not only, dissolve the case, he can arguably pardon himself, that has to be tested, but there are a number of ways he can make this all go away. she has the advantage of being a state prosecutor, and it can't be pardoned. And in Georgia, the governor can't intervene, and all these other reasons. But you also expressed your, concerns, let's say, as a prosecutor, former prosecutor, about the size of it. 19 co-defendants, how she could ever bring it all to trial so quickly. So do you expect that some of these will fall by the wayside, will come up with plea deals? Will maybe some of those who are unindicted co-conspirators in the federal case, she and Jack Smith will work together to clear the deck with some sort of a universal agreement and create these witnesses, these insiders?
Yeah, so two points. One, I just don't anticipate that there will be a trial of 19 people in one trial. That is a nightmare for the government, and it is totally a good thing for the defense. I mean, imagine 19 defense lawyers and the havoc they can create. But I think to your point about the pardon power, that is where it is true that Donald Trump, if he becomes president again, has that power, but not as to the other 18 people, to your point, Katie, who were just charged. Those people are going to be tried. And they have a real problem because they can't count on a pardon from Donald Trump, whether he wins or not, whether an ally of Donald Trump wins or not. They have the classic problem of a defendant who has been charged trying to decide, do I face the music or do I decide that I want to be on the other side of the V, in other words, on the United States side of that, or in this case, the state side?
You know, since Garrett brought up the literary reference, Katie and I were talking before we went on the air that when we read the Jack Smith indictment and when we read this indictment, they were very, very different. Jack Smith reads, I don't want to say like a beach read, but it's very readable. He tells a story, right? You can follow it very
last
easily.
week it was a beach read for me while you were doing the last indictment, I will say.
And you guys are just guilty to being nerds.
She was literally on the beach reading it. This is a little tougher.
Yep.
And I wonder if that's just the difference between a state indictment and a federal indictment and the way they usually read. Is it because there are so many more people involved in this one as opposed to just one? Does a more complex story necessarily mean that it's a tougher prosecution?
No, not at all. And in fact, Barb McQuaid was on our air last night talking about how she would prosecute this case. You know, look, the way that this indictment is laid out is chronological. And so it doesn't lend itself to the easy narrative that you were talking about, but you could separate these overlapping schemes into different buckets. Yes, there's the fake electors scheme, but there's also the pressure campaign on Ruby Freeman and Shay Moss. There's false statements in litigation filings. There's false statements to legislative hearings that were used to try and pressure Georgia legislators to come back into a special session. So there are definitely stories here. You just have to sort of disaggregate the chronological story and put them into their proper buckets with what these people were trying to accomplish and with whom, and then think about it all together to serve the common purpose of overthrowing the election for Donald Trump.
Donald Trump already tried to get the New York case pushed to federal court. It did not succeed. Chuck Rosenberg, is there a chance that this one might get pushed to federal court?
Well, there's certainly a chance, Katie, that he's going to try and get it pushed to federal court. I mean, there's a statute that permits a federal officer acting within the scope of his or her duty to petition to have a case removed from state to federal court. He has a better argument here than he did in the New York case. I don't think he has a great argument here because at the end of the day, committing a fraud is not within the scope of a president's duties. So will they argue it? Absolutely. Do they have a slightly better argument than they had in New York to have it removed? I believe so. Will they succeed? I doubt it.
Chuck, I also want to play what Tim Politeri, who's now representing Bernie Kerik, previously representing Donald Trump, as you know, what he told us just this last hour about Rudy Giuliani and Sidney Powell relating to the whole the lawyer made me do it, or the lawyer told me to do it. Let's watch.
based on my representation of multiple people, not just the president, but also Bernie Kerik. I will say that Sidney Powell is one of those lawyers that everything I've seen, she was putting out theories that she didn't have any backup for. And that was actually one of the things that, this indictment makes it seem like Rudy Giuliani and Sidney Powell were shoulder to shoulder. Everything I've seen is actually quite the opposite.
Do you see, first of all, some of these players beginning to separate? And is the lawyer maybe do it, is that a risky defense because it could lead to waiving attorney-client privilege and opening a whole can of worms?
Yeah, so first question first, Andrea. You often see co-defendants begin to separate. They have different levels of culpability and different levels of exposure. And to Andrew's point, some of them make a calculation earlier than others that they would rather be on the other side of the equation. With respect to an advice of counsel defense, it's a real thing. I don't know that it's going to be available here in the way that Mr. Trump and some others might like. It requires a couple of things that may be a little bit painful for them. For one, you have to waive attorney-client privilege. So all of the advice they've gotten and all of the communications that each of the defendants have had with whatever lawyers they want to point to is going to get turned over to the government. That could make their lives, the defendants' lives, harder, not easier. Then second, and I'm oversimplifying a bit, in order to have a reliance on counsel defense, you have to have acted in good faith. We talked about this quite a bit when the second Jack Smith indictment was unsealed. There's a lot of bad faith in that indictment. There's a lot of people who told Mr. Trump, and he's the lone defendant, of course, in that federal case, that his fake electoral scheme was unlawful, that he had no good faith basis to do what it was he wanted to do. Without a good faith basis, an advice of counsel defense is doomed to fail. So, can they try it? Sure, they can try it, but I think it's going to be a very bumpy path for a number of the people who might otherwise wish to rely on that at trial.
Katie Phang, let me go from the legal to the logistical, because it's very clear that over the course of the next 10 days, at some point, all 19 of these defendants are expected to show up, and they're going to be the mugshot's going to be done. They're going to get their fingerprints done. What do the 10 days look like where you are right now? How is that going to unfold?
Well, we had an increasing amount of security outside of the Fulton County Courthouse in advance of just the unsealing of an indictment, or indictments plural, at the end, as we know. It ended up being only one. But consider the following: 19 co-defendants, all having to surrender themselves on or before noon of Friday, August 25th. So what does that look like? Well, the surrendering process in and of itself is usually different than the arraignment. We've seen this happen before. Former President Trump claiming he can go and get his bond status dealt with as he surrenders himself, but then he didn't have local counsel, for example, in the Miami case, and so he had to try to get that. What's kind of the difference here is he already has local counsel on the ground. He's been using local counsel for a while. That makes the timing very different. But if you are the police, if you are the court deputies, if you are the chief judge here, you're going to try to minimize the exposure of risk of harm to any of the people in light of somebody like Donald Trump showing up here. But if you don't show up, and let me make sure this is clear, there are already arrest warrants that have been issued for all 19 of these co-defendants, including Donald Trump. If they don't show up, they can be considered fugitives from the law, and they can be arrested and held until they brought in front of a judge to address their bond status and to explain why they didn't show up. And so there's a lot of peril at hand for these defendants if they elect to just ignore the fact that they're facing an indictment in Fulton County right now.